Every video you've ever uploaded to YouTube, every song, every vlog, every second of your voice. Google's lawyers just told a federal judge that you already licensed all of it for AI training. Not with a contract you negotiated, not with a payment you received, but with a checkbox, one you probably clicked years ago without reading a word. And in the next few minutes, I'm going to show you the exact clause they're pointing to, the 21-page policy paper Google published 17 days later that's designed to make this legal forever. And the 2 court rulings landing this summer that will decide which way this goes. And if you upload anything to the internet, this is your fight, whether you know it or not. Let's start with what actually happened, because the timeline matters. In February 2026, Google launched Lyria 3, its AI music generator inside the Gemini app. Over 750 million monthly users can now type a prompt or upload a photo and get back a 30-second track with vocals and lyrics. The Pro version goes up to 3 minutes with structured verses and choruses. 1 month later, in March, a group of independent musicians sued Google in federal court in the state of Illinois. Singer-songwriters, producers, and working bands. Their complaint runs 118 pages, and the core allegation is simple. They say Google trained Lyria on copyrighted recordings pulled from YouTube. At least 44 million clips, 280,000 hours of music. And here's the detail that makes this lawsuit different from every other AI copyright case. They're quoting Google's own published research papers. Papers from 2022, papers from 2023, where Google researchers described scraping around 50 million internet music videos. The artists point out that neither paper mentions a license, neither mentions consent, neither names a single rights holder who was asked. Now, in most AI lawsuits, the company's defense is fair use. Suno's lawyers argue fair use. Udio's lawyers argue fair use. That's the standard playbook. But Google did something different, and this is the part that almost nobody is talking about. On June 8th, Google filed a motion to dismiss, and its lead argument isn't fair use at all. It's a contract argument. Now, this is what matters. Google says these artists already gave permission. When they uploaded their music to YouTube, they agreed to the terms of service. And buried in those terms is a specific clause granting YouTube and its, quote, affiliates a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use uploaded content, including the right to reproduce it, distribute it, and prepare derivative works from it. And who are these affiliates? According to Google's filing, that means any division of Alphabet, which includes Google and DeepMind, the lab that built Lyria. So follow the logic. You uploaded a song to reach listeners. Google says that upload was also you handing the entire Alphabet empire a free, transferable license to feed your work into an AI model that generates music that competes with yours. No extra permission needed, no payment owed, you agreed. Remember? Here's what the other side says. The attorney for the artist points out that Google hasn't shown a single plaintiff ever actually agreed to those terms. The Music Artists Coalition dug into the fine print and found the terms Google is citing date back to 2019, years before generative AI hit the market. The words artificial intelligence appear nowhere. The word training appears nowhere. The position is blunt. A checkbox from 2019 is not informed consent for something that didn't exist yet. And notice how carefully Google words its own position. Google has never confirmed that these specific artists' music was in Lyria's training data. The argument is conditional. Even if we did, we had a license. That's a lawyer's sentence, and it's doing a lot of work. But here's the part that should get your attention, even if you've never uploaded a single song. Google has confirmed on the record to CNBC that it uses YouTube uploads to train Gemini and Veo. not just music models, its flagship AI, and its video generator. The same terms of service covers your tutorials, your vlogs, your gameplay, your face, your voice. I upload under those terms. You upload under those terms. This case is about musicians, but the clause is about all of us. Now, 17 days after filing that motion, Google published something else. And when you put the two documents side by side, you can see the whole strategy. On June 25th of 2026, Kent Walker, Google's president of global affairs, published a 21-page policy paper called A Pragmatic Approach to AI Governance in America. It's not a blog post. It's a formal document aimed at Congress, aimed at regulators, and honestly, aimed at the judges hearing these cases or those that will hear these cases in the future, most likely on appeal. I've linked the full PDF in the description, and I genuinely encourage you to read it because it's well written, it's reasonable in tone, and that's exactly why you need to read it carefully. You need to be aware of what you are agreeing to and be okay with that. And if you're not, that's okay too. You'll have to find another platform and you will have to find a way to agree to that platform's terms going forward, which I guess they will take Google's and just use them anyway, right? Okay, the paper makes 3 interlocking claims. Number 1, training AI on publicly available web data is, quote, transformative, non-expressive use. That phrase is not casual. It maps directly onto the fair use doctrine. Google is drafting the legal standard it wants courts to adopt. Number 2, regulate outputs, not inputs. If an AI generates something that copies your song, that's infringement. But how the model is trained shouldn't matter. Number 3, opt out, not opt in. Responsible developers should let rights holders exclude their content using machine-readable tags. The default is that training is allowed, and the burden is on you to object. That third one is the entire war in a single word. The music industry, the labels, the artists suing AI companies, they all want opt-in, explicit consent before training. Google wants opt-out. Silence equals permission. Those two positions cannot both win. One of them is going to have a ruling by a judge, and then it's going to go through appeals, and we'll see how far it goes. The paper also uses an analogy you've probably heard before. It compares AI training to, quote, an art student taking inspiration from walking through a gallery. It's a lovely image. It's also doing exactly what analogies do inside of legal fights, which is smuggling in a conclusion. An art student walks through a gallery once and comes out changed. Google's crawlers ingested tens of millions of recordings at industrial scale to build a commercial product that generates competing works on demand. If I walk through the Louvre in France, I don't come out the other side able to print Mona Lisas for 300 million customers. One of the plaintiff attorneys in these cases has a sharper phrase for it. Not inspiration, extraction. The paper also proposes a new regulator, a frontier AI regulatory organization, FARO, F-A-R-O. That model loosely based on FINRA, the body that oversees the securities industry. Industry funded, federally supervised, annual audits, real standards. And look, credit where it's due. That's a serious proposal and parts of it are genuinely thoughtful. But watch what FARO is scoped to cover. National security, cyber threats, biological risks from frontier models. Now watch what it doesn't cover. Training data, licensing, consent, compensation for creators. Google is proposing a real regulator for a different problem, and the problem it skips is the one where Google is currently a defendant. And then there's my favorite phrase in a whole document, value exchange. Google says it has paid for access to specialized, non-public content, paywalled material, content from big publishers with negotiating power. That Google decides to pay for. But publicly available web data, which is the category covering basically everything an independent creator has ever uploaded, that's fair use, free. So the value exchange works like this. If you're big enough to make Google negotiate, you get a check. If you're an independent creator who uploaded your work to find an audience, you get a thank you note. Actually, you don't even get the thank you note. So that's the two-track strategy. And I want you to see it clearly because the video that inspired this one and most of the coverage out there blurs these together. In court, Google argues contract. Your TOS checkbox was a license, so fair use doesn't even come up. In policy, Google argues fair use for the entire open web, so even content it doesn't host is fair game. Track 1 protects Lyria. Track 2 protects everything else. Google owns the platform and is lobbying for the law. No other AI company on earth is positioned to run both plays at once. Now, why does the timing matter? Because this summer, the whole question could actually get answered. The big one is the record labels versus Suno. Quick history. The RIAA sued Suno and Udio in June of 2024 on behalf of Universal, Sony, and Warner. Since then, the labels have split. Universal settled with Udio and is building a licensed AI music platform. Warner settled with Suno. Sony settled with nobody. Sony is betting everything on a court ruling. And during discovery, the labels got expert access to Suno's actual training data, ran audio fingerprinting on it, and found millions of their recordings inside. They've asked the judge to expand the case from 560 songs to 61,026 songs. At a $150,000 per work and maximum statutory damages, that's a theoretical exposure of over $9 billion. Suno's response to that number was to raise $400 million in fresh funding, which tells you how confident both sides are, or at least how good their poker faces are. A summary judgment hearing on the fair use question is on the calendar in federal court in Massachusetts, and a German court rules on a parallel case against Suno this coming July 31st. However these land, they're the first real answers to the question every AI company has been building on top of. Is training on copyrighted work without a license legal, or is it the largest infringement in history? The judge in Massachusetts is essentially choosing between Google's framework and the music industry's framework. Both cannot be true. One last piece. Because Google supports it, and you should understand why, the No Fakes Act. It's a federal bill creating a digital replica right. It protects your voice and your visual likeness from being cloned without permission, living or dead, with takedown obligations for platforms. That's real protection, and it matters. But look at what it protects and what it doesn't. It stops someone from generating a fake you. It says nothing about your own actual work, your recordings, your videos, none of it that could be used as training data for the model that does the generating. Google endorsing no fakes cost Google's training pipeline exactly nothing. It's the protection you get instead of the one that you asked for. So what do you actually do with all this? 3 things. First, know what you've agreed to. Go read the license section of YouTube's terms of service. It takes 4 minutes. I read it so I can make this video, and you should read it because you've signed it. Second, if you publish on your own site, look into machine-readable opt-outs like Google extended in your robots file. Under Google's own proposed framework, silence is consent, so don't be silent. And third, watch what happens in these courtrooms over the next 60 days, because the outcome sets the terms for every creator on every platform, and I'll be covering the rulings on this channel the week that they land. Here's the bottom line. Google isn't just defending a lawsuit, it's writing the rule book it wants to be judged by, and the checkbox you clicked years ago is Exhibit A. So here's my question for you, and I genuinely want to know, when you uploaded your content, did you understand you might be granting an AI training license? Yes or no? Tell me in the comments. Because I think the answer from real creators matters more than anything in that policy paper. The Google paper, the court filings, everything I cited today is linked in the description of this video so you can check my work. If you want to actually own your own AI layer, instead of being someone else's training data, hit that subscribe button. It'll really help me out, and it will feed the algorithm so others can see this video. Because that's what this channel is about. And I want to thank you for watching. Place any questions you have in the comments. I'll be happy to read them and answer them myself. I'll see you in the next one. See you next time.
Hey, don't forget to hit that subscribe button and check out these other videos to the right.